Final case of this morning is 25-0743, William England versus Progressive Select Insurance Company. Council, whenever everybody's ready. Again, you have 20 minutes, 5 minutes rebuttal time for the appellant, unless you tell us a different amount of time. And if, when you get in your rebuttal time, the yellow light will go off. And obviously you can stop then or you can continue on, but your aggregate total is 20. All right. Council, ready?
Yes, Your Honor. Good morning, the court. I would like to stick with the 5 minutes rebuttal time.
Okay, very well, thank you.
William England here on behalf of the plaintiff. William England, I know that seems duplicative, but
So you're not the actual plaintiff?
I am.
You are the plaintiff?
I am. I employed the services of Chad Bar Law. They went to court in front of Seminole County Judge Gruner, and Judge Gruner dismissed the complaint. Okay. I then volunteered to handle the oral argument because I have been here more than just a few times, and I think I know the facts and the law a little bit better than this one, if that's all right.
No.
So we are here asking the court to reverse the trial court.
I was only asking is whether you were not the plaintiff, you just happen to have the same name.
I know.
But no, you are the plaintiff and you are, that's fair enough. Go ahead, counsel.
So in this particular one, we're asking the court to reverse the trial court's improper dismissal of a 2-count complaint. In this particular matter, the complaint filed was count 1 for declaratory relief.
What was the total dollar amount that you were claiming below?
Oh, the total dollar amount claimed in the breach of contract, count 2, was for $15.
Okay.
Plus any appropriate cost or attorney's
And so it was
fees
a breach
that
of
may be
contract
awarded.
claim, correct?
That was the breach of contract.
Did you attach a copy of the policy, or did your attorney attach a copy of policy to the actual complaint?
We did not. The complaint alleged, I believe it's in paragraph 7 or paragraph 8, that we did not, that the plaintiff did not have a certified copy of the policy.
Was it required though you did not? Were you required to have a copy of that, or aren't you required to have a copy of that attached to your pleadings?
The case law sets forth that if a party does not have the underlying contract, specifically the certified copy of the policy, then they may allege it specifically through reference within the complaint. It is then incorporated by specific reference within the complaint, as long as they allege we don't have a copy, but the defendant does have a copy.
So the trial court apparently seemed to grasp hold to dismiss this based on the fact that this was de minimis. Why is this not de minimis?
Well, this one is two parts here. I would like to highlight the court made a few rulings. First, they alleged that the DEC action was dismissed for de minimis. The DEC action did not have a monetary claim for damages. It was seeking clarification of the contractual terms, specifically where in the policy does it state that Progressive may charge an additional fee or interest, and does it clarify how that interest will be calculated? Those were the DEC actions. Those are the requests.
So just to answer
Under
this,
Chapter 86.
and I understand you're representing yourself, the specific question of why does this not fall under the de minimis doctrine, this doctrine?
This one does not fall under the de minimis because de minimis does not first apply to DEC actions. Under the breach of contract, de minimis does not apply because this is a material issue. Specifically, to highlight it, the installment payments were set at a certain amount. The parties agreed to those certain amounts. Then, because there was a 5-day delay, Progressive charged $5 of interest. There's no idea how that was calculated. Then the payment was issued and the interest was paid minus 2 cents. Upon those underpayment of 2 cents of interest, Progressive then charged an additional $10 of an undisclosed fee. This court has previously addressed the de minimis issue, specifically in Baker Cairo.
So Baker deals with PIP cases and attorney's fees issues. That does not seem to be the same type of thing here, correct?
Well, this is a policy of insurance, but I would highlight there is a great quote from the Baker matter that stated, when addressing the precision diagnostic case, that the doctrine of de minimis non curat lex should not be the motto of small claims courts where this matter was filed. And specifically, the precision issue dealt with a $4 12 cents or 15 cents, right? Another issue was $1.48 of interest under the Baker Cairo issue. Now,
But I think, didn't Judge Evander in the Baker case, I mean, he really focused on the attorney fee provision? I mean, wasn't that kind of the rationale of why he did not go along with the precision case, correct?
yes, Your Honor, he did address it that way, but I do want to highlight
So what is
that-
the difference here?
the difference here is for the same reason why we disagree with the precision matter in Baker. Specifically, when you are filing a lawsuit, that every member of Florida has a constitutional right to access to the courts. We know that from Article 1, subparagraph 21, I believe. Then we go through the jurisdiction of the courts. We have the circuit courts and county courts. County courts are up $0 to $50,000. And there's a special subsection of rules specifically for matters or claims dealing with $0 to $8,000.
Did you file this in small claims court?
We did file this in small claims court under the county court jurisdiction because the filing fee was less, because the jurisdictional amount was alleged to be less than $100. The county charged a filing fee that's based upon $0 to $100 jurisdiction. There is no basis in statute or within the Constitution that would support closing the courthouse doors or stopping litigants from being able to pursue matters.
Why is this $15 so important to you?
Well, it was more important to Progressive to highlight that because if I did not pay the full $5 of interest as exemplified and alleged within the complaint, they sent a cancellation notice with a threatening thing saying if you don't pay this $2 of interest as well as the $10 fee that we just made up, then we're going to cancel all your policy coverage, even though you paid all your premium. And we're going to report you to the state of Florida, which could result in your suspension of your license if you don't have insurance. So it is equally important to both sides. And that's why we do have a current dispute between the parties. And then to highlight, there is a potential, and it's plaintiff's position, that the trial court abused its discretion by setting a floor when there is no statutory or constitutional basis for a floor. It is not set forth $15 to $100 or $20 to $100.
So if you filed suit for 5 cents, that would be okay, and then you could not use the de minimis non-curate lex doctrine if you're a trial judge?
They could, but that would be more under an analysis as to the intent and the purpose of the litigation, not at a motion to dismiss stage. Take in mind, Precision went all the way to summary judgment. So did Baker Cairo. In this instance, the trial court was required to look at the four corners of the complaint, take all the well-pled allegations as true, and make a ruling based upon that.
Did you pay the $15?
I did.
Okay, but you disputed that you owed the $15.
Absolutely, because there is nothing from my review of the policy of insurance that clarified or placed anybody on notice that Progressive was intending to charge $5 of interest based upon 5 days of being late, or that they intended to charge $10 fee without any disclosure based solely upon underpayment of the interest. So it was important enough to Progressive for that instance, and highlight more again, the jurisdictional balance is 0 to 100.
Does the answer brief filed in this case give, I mean, I'm probably anticipating where you're going to go with this, but does the answer brief suggest the statutory reasons for both the $5 charge and then the later $10 charge?
The answer brief does, and that was absolutely where I was going to go, because both sides are arguing now today the rule of preservation. It's important to highlight at the trial level, Progressive never raised any statutory basis for interest. Progressive never raised any statutory basis for fees. That was never preserved within the trial record. That was never raised within the motion to dismiss. It was never raised within a response to the motion for rehearing. And more importantly, the defendant never even filed the policy of insurance. Because, keep in mind, the DEC action was not asking for a statutory interpretation. The DEC action was asking for contractual interpretation.
Does Florida statute 627.841 allow them to collect this fee?
627 point what?
841 that they rely on, does that allow them to collect this fee?
Honestly, we don't know, because, actually, no. I'm going to say no. Then the reason is this. A statute can state that an insurer may collect a fee or may limit reimbursement. To borrow from PIP, because I have some experience with that, we know that virtual imaging from the Supreme Court stated that a statute, when it uses the word may, is permissive in nature. However, if parties intend for it to apply to a contractual agreement, then it must be within the contract. It has to be adopted, it has to be provided within notice of the contract. So it's plaintiff's position that if a statute allows Progressive to charge a fee and they don't add it into the contract, then it's not part of the contract. That is right in line with the virtual imaging, for example, the fee schedule elections of Medicare Part B. The statute may allow it, but if you don't tell people you're going to use the fee schedules, then you cannot. The similar analysis would be here. If the statute would allow you to pay, to charge a fee or charge interest, and your policy, your contract does not, then contractually, you are not allowed to collect that because you did not add that into the meeting of the minds when we negotiated the contract. And so the answer on that one would be no, but I also would highlight that under the rule of preservation, again, the defendant did not raise that at the court level. They did not file the policy of insurance, which is also why I wanted to highlight the error of the trial court order. Because in the trial court order, the trial court dismissed the DEC action based on de minimis. They also found that $15 is trifling under the laws of equity. And that does not follow with this court's precedent in Katsuma even. Because we dealt with Katsuma where the insured person was being sued. They wanted to have the insurance-related defense counsel represent them. The insurer refused. They then filed a DEC action just to say, hey, you owe me an attorney to represent me. And they prevailed. There is no basis to deny DEC actions based on $15 being trifling in equity, especially when the party under Chapter 86 has every right to seek clarification under the policy of insurance. We're even allowed to ask for clarification before a breach occurs under the Chapter 86. And it's not just asking for advice. This is a legitimate dispute between the parties. Was there a contractual basis for the defendant to demand $5 of interest, how they calculated their interest, or demand the $10 fee if you underpay interest? We're not arguing over underpayment of policy premium. We're arguing over the threats regarding the defendant's demand for interest and fees.
Is it your position then if they filed their motion to dismiss and attached a copy of the insurance policy and the insurance policy specifically either adopted these statutory provisions or said that they can charge up to $5 in interest on these premium finance payments and they can charge $10 for late fee, then
yes.
Then it would be, you would have a reason to not proceed further.
Absolutely. Then the court would be absolutely within its discretion to dismiss the matter for failure to state a cause of
Looked at you
action.
and said, well, it says it right here. And
Absolutely.
And why they sent you a bill for 2 cents plus $10, that seems trifling as much too, but apparently they can do that, Mr. England. Have a nice day and
Yeah, if it's
go forward and
within the
decide whether you
policy.
want to stay with Progressive or not, I guess, or something.
Absolutely. But that's when it's within the policy and the policy is in the court record. The problem here is that Judge Gruner in Seminole County added to her order dismissing the matter, she found that Progressive did not breach the contract of insurance when there was no contract of insurance within the record for her to even look at. That is an abuse of discretion. To make that type of ruling without even having the document to be able to look at.
She had dismissed it and said, well, you didn't attach under 1.130 and therefore you can't bring because you're bringing a claim under a written contract that's not attached, therefore case dismissed. And then we get into leave to amend discussions and stuff like that. But.
Well, absolutely. At that point, the court has discretion to dismiss, to say write a better complaint or attach necessary documents. However, there is the case law saying a party can incorporate the policy of insurance. Even if they don't attach it, they can incorporate it through specific reference as long as they advise, we do not have the certified copy of the policy, the insurer does.
But you can, if you don't have it, but you can plead the pertinent provisions of the contract and saying, here's the contract, I don't have a copy, they do, but this is what was breached.
Absolutely. And the problem is, even if the court's like, hey, you didn't attach this under Rule 1.130, right? Mm-hmm. A dismissal with prejudice is absolutely improper at that point. If you're dismissing a complaint for failure to attach a necessary document, then a dismissal with prejudice is an abuse of discretion and the most clear line error that we've seen.
You argue that in the motion for rehearing?
We did. And they also stated that, in the trial order, the trial court found that plaintiff failed to plead a breach of contract cause of action. She did not elaborate that it was based on 1.130, failure to attach. She stated, I did not plead a cause of action. Specifically, I did not plead that we had a contract, even though we did, and our briefs and record highlight that. We did, she stated, we did not argue the duties and the breach and the damages. Well, we did make those allegations in both the deck action count as well as the breach of contract count. Now, if the trial court wanted to dismiss the breach of contract as being de minimis, that again would be a slippery slope, because how much higher are we going to continue to raise this bar? To highlight this,
Isn't that a discretionary call?
it could be, but you have to be very careful, because I do want to highlight how slippery this can be. It goes from $1.48 to $4.28 up to $15 now. And based upon the reading of the defendant's answer brief, with their inflation based upon the history of the case law they were using, they even articulated that $110 could be considered de minimis. $300 could be considered de minimis in their answer brief. That's why it's a slippery slope.
Well, I mean, they were citing to an 1858 Florida Supreme Court case that apparently said we're not going to send it back to correct a $9 thing, and they then extrapolated that in today's dollars that would be 300 or something, and
Absolutely.
then that would be an issue about whether that is truly de minimis or not, and whether that wouldn't then go to the abuse of discretion standard, though.
That does go towards the abuse of discretion, but you also have to consider what is the standard based upon the Florida Supreme Court, as well as the filing and the Constitution as well.
I mean, the argument was, or the order basically said, this action is barred based on de minimis non curate lex. She's not really saying that you didn't plead a cause of action. She's saying, or the trial judge is saying, whatever you pled, I'm dismissing it under non curate lex, right?
Well, actually, on paragraph 9, the court also finds plaintiff failed to plead any proper elements of a breach of contract in this case. That was in her
I
order.
mean, if we say that's error, but number 7, paragraph 7, where she says, based on the four corners of the complaint, which is all the corners, all, count 1 and count 2, this action is barred based on the maximum de minimis non curate lex. So whether she was erroneous on paragraph 9, if she is correct on number 7, wouldn't that make it still affirmable? I mean, I understand your argument otherwise, but I mean.
Yes, Your Honor.
I mean, I get what you're saying. You pled it, and it's sufficiently pled, but she doubles down, if that's the correct word. She says, and oh, by the way, you lose on this one too. And, we, okay.
Absolutely.
I don't want to take up more. of
I
your
see
time.
that I'm in my rebuttal time. I'll save the rest of my time for
Yes, sir.
rebuttal.
Thank
Your
you.
Honor. Thank you.
Good morning, and may it please the court.
Yes, sir.
Cameron Fry on behalf of the appellee Progressive in this case. I just want to start out by again citing to the fact that this is not a PIP case. This isn't a claim regarding a dispute of coverage. There was no claim involved in this. The sole issue in this case is whether or not Mr. England should have had to pay $5 in interest on his premium installment payments and then a $10 late fee.
Was the amount in controversy within the county court jurisdictional limits?
By the letter of the law, it was.
So
but
why should the case be dismissed solely on a de minimis amount?
Because, Your Honor, the de minimis dismissal is as was pointed out, a discretionary issue by the trial judge. The trial judge looked at this, and I think it's important to note, too, that this is not a reoccurring issue. As stated by the face of the complaint, this was a one-time occurrence. They're disputing this one-time imposition of a $5 interest charge, which the record, it's actually page 17 of the record, indicates that Mr. England had paid this $5 interest charge before. It's actually charged every single time because, as authorized by statute, Progressive's allowed to charge $5 in interest on premium installment payments. But the dispute in this case involves this one-time occurrence of a $5 interest charge, Mr. England's failure to pay the full amount due and owing, and then Progressive's imposition of a $10
The record
penalty.
attachments, the record is that that's the amount, the 369 figure, that's the amount that he's billed, and he paid it 7 days late, and he was a few cents off?
Correct.
That's what the record shows?
Correct. One of the exhibits attached to the complaint is the actual premium bill, and it shows.
Attached by Mr. England.
Correct. And it shows that the past month, which I think the month in dispute was February, the prior month's bill, which was paid in January, showed that the amount paid was $369.02.
Was the policy part of the record?
It was not attached
How
by the
could the
plaintiff.
trial court tell then that there was not a breach of insurance contract if there was no policy?
Sure, because there was no pleading of any material breach, and I think that goes to our second argument, which is that the imposition of interest charges on premium installment payments as well as the delinquency penalty are authorized by statute. So this is not a policy issue, it's a statutory issue. The statutes control over the policy in this case.
So are you saying the record attachments show that Mr. England has charged $5 interest on each premium bill that he gets?
If you look at, I believe it's Exhibit A, but it's on page 17 of the record. It shows the actual bill that was in dispute, and it says $364.02 of premium, $5 in interest.
But I mean, I guess that's the bill he gets.
Correct.
Like I get it, we all get a bill from car insurance company every year, or whatever you're paying it. So his bill, I mean, it's not like he got $364 and then you guys sent him a bill for $5 more. Is that, the record doesn't show that? And then
No.
What he attached to his complaint?
No, what was attached to the complaint shows that $5 interest charge is part of his bill.
Part of his monthly insurance premium.
Correct.
Or whatever he gets the payment. And then his complaint is he sent in 2 cents less than that bill, and so you guys sent him a bill, for lack of a better term, for the 2 cents plus a $10 late fee, and then that's why, and suit was then filed over the whole $15.
Correct. He got the cancellation notice, which is just like if,
Or the cancellation of his
yes,
policy.
if I don't pay my Netflix every month, they're going to cancel it. It's the same thing. It's the premium installments are paying for the actual contract. So he didn't pay the full amount that was owed. So Progressive, which I'm sure it's probably an automated notice, but sends out the notice saying you didn't pay the full amount owed. We're also imposing a $10 delinquency fee, which is authorized under 627-841. And so that's what this dispute turns
So
on.
he got a $10.02 bill with a notice, oh, by the way, you haven't paid, we're canceling you. But I guess if he paid the $10.02, it was reinstated?
Correct.
That's what the notice said, that's
Correct.
the record?
Yes, it's where your policy is going to be canceled as of this date unless you pay the $10.02. Correct. And so,
Which he said, Mr. England said he paid.
correct.
Okay.
And so that's really what this turns on. And I know the appellant in their initial brief spent a lot of time talking about why this court should follow its prior ruling in Baker, and the trial court erred by not following Baker. As this court is aware, Baker was obviously a PIP suit. It was a lawsuit over disputed interest payments on PIP benefits. The medical provider who had filed the lawsuit at that point obtained a judgment after, I believe, a couple years of litigation. The medical provider obtained a judgment. Then the next issue turned on whether or not there was an entitlement to attorney's fees, whether or not PIP or interest is considered a PIP benefit, thus entitling the provider to recover their attorney's fees. So that was really the issue on appeal. There was the argument and the analysis as to whether or not attorney's fees should be awarded based on a de minimis amount in recovery, but as this court noted, because at that point the medical provider had already secured a judgment, they were entitled to recover their attorney's fees under 627-736 subparagraph 8, which specifically authorizes the award of attorney's fees. But I want to note the court, and I think it was Judge McCarr's concurring opinion that made a point.
Okay, all right, Judge Maker, all right.
Just made a point to reference the fact that de minimis played no role in the litigation. In that situation, it was not raised in the lower court. And in our case, obviously, we raised it the earliest possible opportunity we could in a motion to dismiss the complaint, because this entire dispute turns on this $15, $5 in interest, $10 late penalty. And so in our position, that the trial court did not abuse their discretion in finding that this was a de minimis amount.
Where do you, as to the appellant's argument, where do you draw the line in county court? I mean, you're at $15. I mean, are we 20, 25, 30? I mean, where do you draw the line?
Well, I think that's something that's obviously up to the
You
discretion.
think that's
of-
just
of
a
the-
discretionary call by the court?
That's a discretion by the trial court. And I note some of the cases, especially some cited by the appellant in their brief, that talk about the why you shouldn't apply de minimis in the PIP context. Obviously, as I'm sure you're all aware, in a lot of PIP cases, issues are litigated over smaller amounts because even though it's a small amount on this case, it could affect hundreds and hundreds and hundreds of other cases and obviously turn into something bigger, which is why in the Baker case, I believe that's why that issue was litigated up to that point, because it wasn't just concerning that case, it was concerning other case. But again, here, it's a one-time issue. And so the trial court, in her discretion, said, no, I'm not going to extend jurisdiction, I'm not going to resolve a declaratory judgment action or a breach of contract action.
Well, I lend my neighbor $25 and he agrees to pay me back $25 in a month and doesn't do it, and I sue him for the $25. Can the judge just look at me and says, hey, Lambert, get over it, that's de minimis? I say, well, wait a minute. I can bring a small claims action from 0 to whatever figure, and I've done it, and I'm not being vexatious or I'm not anything. I gave that guy my $25. I was being a good neighbor, and now he stiffed me. I'd like it back, and it's a principle thing because I'm now a retired judge. I got nothing to do but sue people.
I understand it's a principle.
And if the judge says to me, hey, what's the matter? Didn't you make enough money being a judge? Get over the $25. You don't want to have an unfriendly neighbor here. I'm doing you a favor because I'm a paternal judge for you. You're just an old senile ex-judge, Lambert. De minimis, have a nice day. So wait a minute, you didn't pay. I know. You still lose. Get out. I couldn't come up here and say, not for nothing. This is an easy one for you geniuses in Daytona Beach. You should be able to figure this out. I should get a reversal.
I understand.
I
but-
would say to these guys if I was up sitting where you are.
I understand, but that goes to the discretion of the trial court, and it's one of those
So if
instances.
the trial judge in the one end of the floor could say that's de minimis, and if the luck of the draw, I was on the other end of the floor at the Marion County Courthouse and said, well, that's a fair thing, $25 is $25, and that would be under the abuse of discretion standard, no trial judge could have done that. I get what your visceral reaction is, but I think Mr. England makes a fair point. If the Constitution and the statutes allow me to bring suit from a penny up to $100, and I do that, why should that cause angst to a trial judge? And perhaps the legislature should change the statute that says anything under $20 you can't bring suit.
I understand, Your Honor, but we're dealing.
We're all very clear that we
Yeah.
can't be activists here. We got to let the legislature write the
Absolutely,
laws.
there isn't a statute that governs de minimis. Obviously it's a legal maxim, but it goes to, again, and I think we cited in our opinion, it was the third DCA opinion, the Ocean 2 Condo Association. Again, it kind of goes to the duty of litigants to sort of mitigate their damages. Would you spend $300 in filing fees plus a summons fee to try to recover $25? And that's.
Says, I got plenty of money. I know this sounds silly, but this is a principle, and I'm showing my kid. It's a lesson I'm teaching to my kids that if you're wrong, you take it in the proper course. You go to litigate. You behave properly, and you let the courts decide. And that's why we have courts. We don't just draw swords and get into conflict. And that's what I'm doing because in my scenario, the man owes me $25. He doesn't really. Just so everybody's clear. I don't. Wouldn't let any of my neighbors know.
Again, Your Honor, it's our position that this is it's up to the discretion of the trial
Your
court.
position is basically, he could bring suit, but the trial judge, Mr. England can bring suit, but the trial judge exercised her discretion here to declare it de minimis, and that's her discretionary call, and absent a showing of abuse, we should affirm.
Absolutely, Your Honor, and we cite in our brief other instances of courts using the de minimis doctrine to rule on issues, especially not even involving monetary damages. Instances involving illegal search and seizures, equal protection claims. So just because and that's one of the arguments that they raised was you shouldn't dismiss it under de minimis because we're not seeking monetary damage in the declaratory
Isn't there a
judgment
body
action.
of law that you shouldn't dismiss a complaint with prejudice right out from the get-go? I can't remember the name of the Florida Supreme Court case right off the top of my head, that you have to give them leave to amend, you as a trial judge. And now, obviously, if you don't then seek that in a rehearing motion, it may not be preserved. Talking about doctrine we're all very familiar with, preservation here, but how is it, if it's, how can it be a dismiss a breach of contract action as a with prejudice if I don't attach the contract? I mean, I get it what 1.130 says, but it certainly sounds like it could be pleaded if he gets the contract. I mean, that's not an unusual scenario in insurance that you don't have your insurance contract and the insurance company actually has it, and you file a complaint, you know, a deck action or in an insurance world. But I guess
Well, I think that goes to the allegations of the breach of contract claim, which there's no allegations of any material breach. Obviously, we're dealing with an insurance contract here, which the purpose of an insurance contract is the insured pays premiums. In exchange, the insurer agrees to provide coverage against certain losses.
Couldn't they ask for leave to amend and file a request to produce and say, I mean, assuming that the rules of, you know, the civil rules apply to the summary claims action, couldn't they then, you know, request that you guys produce a copy of the policy to him? I mean, he is the insured, so I don't know what your basis would be to object if he did that, but.
I suppose they could, but they never did.
They could. I mean, my point in the context here is, I file a complaint, it gets dismissed with prejudice right from the get-go. I don't get to amend. I can't even get a copy of the contract. I mean, if the judge points out, well, you didn't attach a copy of the contract, therefore it's subject to being dismissal under 1.130. He could say, okay, fair enough, I don't have the contract, but I know you guys do because it's your contract. It's actually his contract too, but he's going to request that you produce it. And I can't imagine what would be the basis for you to, and I'm not saying you would, that say, no, we're not going to give you the contract because if you do, then you'll attach it. We don't like that.
I understand. They did obviously have the opportunity to amend up until the hearing, since there was no responsive pleading.
They had no reason to amend until they lost.
Correct. They never argued. They never argued for leave to amend at the hearing. They didn't raise that.
Did he know he was losing at the hearing?
I'm sorry, I didn't understand.
Well, are you saying he didn't ask for leave to amend at the hearing? Why would I ask for leave to amend at the hearing until I found out I lost?
They didn't raise it in their motion for rehearing either. So
I thought he said he did. He said he.
I don't believe they raised that in their motion for rehearing. If I'm
Well, he either did or he
if I'm incorrect, I stand corrected. But Your Honor, again, that goes back to what we were talking about earlier: is the fact that these fees or these interest charges and delinquency fees are controlled by statute. So even if they attach the contract, if there's a conflict between statute and the policy.
That may well be. I think that's what he's arguing here today. That may well eventually play out, but at the point in time when the trial judge ruled, that wasn't argued in the motion to dismiss, was it?
That was not argued in the motion to dismiss.
So, you know, it's fair for Mr. England or his counsel at the time saying, well, I'm coming to the hearing to be prepared to respond to what the motion to dismiss argued, not something that may be argued.
I understand. This court has the ability to take notice of these statutes, obviously. I mean, it was we cited the Barnett Bank case where that was actually a first DCA opinion where section 658.61 was not raised in the trial court, but it controlled the dispute. And the first DCA noted that it must be followed by the court even though it was not raised in the trial court. And in this situation, because these interest charges, delinquency fees are controlled by the statute, even though we did not raise it in the trial court because they control this issue, this court has the ability to follow it. So that would be my response to that, Your Honor. And obviously, 627-902 authorizes Progressive charge the interest fee. 841 authorizes the imposition of the delinquency or the late fee, whatever you want to call it. So again, these statutes control over the issues in the policy. And so
I think Mr. England was arguing, I mean, he can clarify this on rebuttal, is that if the policy says that, and you allege that in your motion to dismiss, and that's what it says, and you charge me what you're permitted to charge me under the policy, then so be it, but that's not how the matter was framed when it was heard and his case was dismissed with prejudice. I mean, you know, why you would file a notice over 2 cents and charge them $10, I mean, I guess that's an internal decision, but I mean, if it's permitted by the contract, so be it, and then, you know, he then has to make his decision whether he wants to continue being
Well, it's-
insured by Progressive, but,
Well, it's our position that's permitted under statute, and so it doesn't matter what the contract said. The statute allows Progressive to charge these interest charges and delinquency fees. So regardless of whether or not the contract says that, the statutes would control
well,
over
if
the
it says it
contract.
allows it to do that, I mean, don't you have to, I mean, doesn't it allow you not to do that then?
I don't,
You're not required to do that. If it permits you to do that and you engraft that as part of your contract, that's one thing, then he's bound by it. But if your contract doesn't say that I will charge you up to $5 interest on each premium payment, is that?
I understand, but it seems like, where the appellant is trying to take advantage of their own pleading mishap. I mean, they had the ability to attach the contract to the complaint, and they didn't do so.
What if he doesn't have it?
I would, everybody should have a copy of their contract. I mean, they could have obviously requested it.
Everybody should not commit crimes too, but apparently that happens.
That's true.
We have cases involving that, but, you know, I'm not trying to be facetious, but I mean, he's saying, all right, I don't have the contract.
That's true.
That's not a dismissible with prejudice scenario, because he can still plead a cause of action. I mean, we look at that as an abuse of discretion, saying, all right, he doesn't have it, but he can get it, and then if he can allege the breach because of whatever the terms of the contract is, then, you know, the case gets decided on the merits. I mean, I know it's been decided on the non-cura lex position, and I guess that's a discretionary call. I guess that's probably at the end of the day. I mean, basically, the trial judge here, as I'm understanding it, said, I'm dismissing this on de minimis non-curate lex. There's no reason for leave to amend because it's always going to be a $15 claim, which she has decided under the facts of this case, based upon the pleadings, is de minimis non-curate lex, and therefore the case is over because there's no reason to give leave to amend. And so we're here today as to whether she abused her discretion in doing so. I take it that's what everybody's talking about.
Correct. And I don't know why the trial court went to the extra step to say that the breach of contract is dismissed for separate reasons, but it all
Doesn't
ties.
matter. It frankly doesn't matter in the big picture. I mean, if it was error to dismiss if it was an abuse of discretion under de minimis non-cura lex, then the other part's error too, because leave to amend, assuming it was asked for in the motion for rehearing, should have been granted because, I wish I could remember the Supreme Court case that says that. But.
Correct. And I think just to sort of tie the bow, if we come back to the de minimis issue, the Fourth District's reasoning and position, even though that also involved a PIP case, very sound reasoning. There's no reason why the trial court could not have applied the de minimis doctrine to this case, since the only dispute is these $15.
We didn't hold as a matter of law that $1.48 in the case that Judge Edwards wrote about. We didn't hold as a matter of law that that's not de minimis, right? And
Correct.
It was a determination made on the facts of those cases. We didn't set a floor or a threshold at saying if you're above $1.48, it's not de minimis.
Correct.
If you're below $1.48, it is, and everybody has their marching orders from there. So,
Correct. So looks
All right,
like I'm out of
Counsel,
time, so I appreciate it. Thank you.
all right, thank you, guys. All right, Mr. England, you have 3:09 according to the clock.
All right, thank you very much, Your Honor. On the preservation issue, I just want to highlight again, because in the answer brief, my colleague attempted to argue tipsy coachman, and he gave the case law. I want to clarify, the case law holds that that can be used as long as the argument has a reasonable basis in the record. For example, you have to have the evidentiary support in order to argue tipsy coachman or argue what my colleague wants to argue.
Well, does it have to be evidentiary per se? Because here, I don't think the trial judge is disputing is your monetary claim is $15, and she's made a determination that that's de minimis and therefore dismisses the action.
Well,
isn't that
yeah,
accurate?
she ruled that way both on the deck action and the breach of contract.
Right. I mean, she said this is a $15 claim, however many causes of action he wants to assert for this. At the end of the day, he wants a determination that he shouldn't have had to pay the $15. They erred in requiring him to do that, and he should get his $15 back.
Absolutely, or at least we should get an answer from the court that interpret the policy and gave us that interpretation pursuant to Chapter 86. Because we do know that under Chapter 86.021, any person can petition the court to seek clarification of unsure duties or rights under any written document such as a contract. We have that right under that statute. To rule that de minimis would invalidate that statute is absurd. To say you don't even get to ask about your contractual rights, you don't even get to figure out the ambiguities that you and your insurer are fighting over, because it could potentially only be $15. That completely rewrote or invalidated the statute, which we cannot do. The legislature can get rid of the statute if they don't like it, as you pointed out, but the court cannot. And then again, my colleague did articulate that the statute, the Chapter 627-901 allows them to charge this. Guess what? That's not in the record either. They could have done a motion for judicial notice under 90.201, and then it would have been in the record. Not done. Could have been argued at the trial level or in response to our motion for rehearing. Again, not done. So the entirety of my colleague's argument regarding the statutory permissive language that unequivocally says may cannot be considered for the first time on appeal. Now, to go further on the abuse of discretion standard, again, how slippery is this slope going to go? Because if we're going to go as far as invalidating a DEC action statute that allows you to ask for clarification under a contract about your rights, even if there's no monetary damages, how much further can it go? Well, at that point, to highlight absurdity, Florida Statute 812.014, petty theft, any theft under $40 should not be considered, or the court shouldn't waste their time simply because someone stole a lesser valuable item. That is not the intent nor the purpose of the law. And so I ask the court to reverse the trial court's ruling, reverse the dismissal with prejudice, and allow the matter to continue at the trial level. Thank you for your time.
Okay, let me ask you, are you an attorney?
I am.
Oh, okay, I was going to say, well, you did a nice job if you're not an attorney, but no, you're an attorney, okay. All right, thank you, counsel. Have a good day. Well argued, very interesting. All right, we will stand adjourned.